Hello there, my friend, and welcome back. Thank you very much for joining the show. My name is Gavin, and here on my channel, we like to get into the nitty-gritty of true crime. We like to cut through the fluff. We like to cut through the sensationalism. We're steady Eddies here. We're even Stevens here. We like to just get into. We like documents. We like stuff we can get our hands on. I was telling Josh Ritter the other day when I was on Courtroom Confidential, one of my favorite things is going into old places with like dusty and dusty piles of papers and old filing cabinets. I love getting into that stuff. I love finding old things. We didn't have to do that here though, because this is a new thing and it's digitally filed. But the sentiment is the same. We're still getting into the nitty gritty, right? The documents. Now, who are we talking about? We're talking about Donna Adelson. Donna Adelson, you know what? Let's stop. Let's go back. Donna Adelson was recently convicted in the murder of her former son-in-law, Dan Markel, back in 2014. She is the fifth person to be convicted in this crime. Of course, her son Charlie's girlfriend, Katie Manbagua, and then her co-conspirators, Luis Rivera, Sigfredo Garcia. But we're talking about Donna here. Okay, Donna with her little tiny ear holes. Now that was superfluous. Why did I have to do that? Why did I have to do that? I just said we'd like to cut through the sensationalism. Gavin needs to stop, okay? All right. Donna Adelson was just convicted. What was that? A couple weeks ago? We had Joel from Surviving the Survivor on to talk about it. We live streamed the trial. I felt it may have been the most fair trial I've ever seen. I loved the judge. He was happy-go-lucky dude, and yeah, just presided over his courtroom. I thought fairly, and I thought, um, you know, according to the law. But Donna says nay, nay. Donna does not say nay. Donna says nay, nay. I got issues, says Donna. And those issues are brought to us in verbal form, in written form, let's say, in the form of a motion for a new trial and for leave to interview jurors. I mean, I'm just exhausted already. Yesterday I was full on yawning because it was my third video of the day. It had been a long day. But I'm not exhausted in that way. This person exhausts me, okay? The I mean, there I mean, you can't ignore that there was a murder here. It was Dan Markel, but the stupidity of this family, it just boggles the mind. My mind is a boggling. All right, let's check in with y'all. Just see how you're doing. You guys know if you put GF in your comment, I will see it on this side. Susan says I'm entitled to get snarky like the rest of us. This is a little snark. This is true. I'm feeling snarky, and that is true. I also noticed an earlier comment from Susan that was like, "Oh, what a surprising development," she says, sarcasm dripping from her tongue. No, this is going to be the life of Donna Adelson for the rest of her natural days, which I hope are long upon the land and fruitful within prison, as fruitful as they can be. I hope, I don't know, she thinks a lot about what she did and tries to reconcile it and asks forgiveness. I don't know. Uh, yeah, but this is going to be the rest of her life. She's going to be filing motion after motion after motion. This is just what happens. Robin says, I think you have what we call the simples, too tired for complicated thoughts. I was telling Kimberly recently that um, I am going to have dementia. That is going to happen to me. I'm going to have dementia, and it's already starting because I have a hard time pulling words. I have a hard time pulling words out. And guys, I speak multiple languages. Sometimes I can pull the words from another language, but I can't in English. It's really funny. Uh, let's see. Let's talk disabilities. Did you see the video of the judge in this case making a joke to the jurors? I don't remember the joke, but it was something like, "Go home before I change my mind." Yeah, he was a playful kind of a guy. He asked him, "Hey, do you like the snacks I got you? I did it myself. Went to Costco myself." He's that kind of guy. And I mean, I loved him. I thought it was great. I mean, you don't have to be stodgy and stuffy out up there on the bench. Got to do a good job. Got to keep the fidelity of the law intact. And I think he did a really good job. Okay, let's get into this 18-page document, which isn't as long as you would think. At 18 pages, it's not much. Defendant's motion for new trial. Now, spoiler. I believe I saw a snippet of Joel's show yesterday. I believe that this document is going to reference Surviving the Survivor, which just makes me happy as can be. Okay. Comes the defendant by and through the undersigned counsel pursuant to blah 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 requests that this court grant a new trial and in support thereof states as follows. A jury convicted Mrs. Adelson as charged in the indictment on September 4th, 2025. Not quite 2 weeks ago. This motion is timely, filed within 10 days of the rendition of the verdict pursuant to rules blah blah blah. Mrs. Adelson requests leave to interview juror number 5 and juror number 7. Mrs. Adelson files this motion for a new trial on the following grounds. 1. Juror misconduct. 2. Verdict is contrary to the law or weight of the evidence. 3. The court erred in a decision of any matter of law which arose during the trial. In a decision of any matter of law? Okay. And 4, for other cause not due to Mrs. Adelson's fault, she did not receive a fair and impartial trial. Okay. Now, hey, remember what Josh Ritter said, right? The prosecution's job is to seek justice. The defense's job is to seek a win. And they have a very wealthy woman here who I'm sure they are happy to take her money and file all sorts of things. Okay, motion for leave to interview jurors. In the court's preliminary instructions to the jury, the standard instruction was read. You are not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication, such as emailing, text messaging, posting information on social media, which is bolded and italicized, or a website, or any other form of communication. Subsequent to the trial, it's subsequent, who cares? Okay, subsequent to the trial, juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. In reviewing juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26th, 2025. A flash drive with this video will be provided to the court, as the undersigned has been informed that particular TikTok was deleted by the juror from her account. If she did that, yeah, not supposed to do that. I don't think it's enough, though. Let's keep going. The undersigned seeks to interview juror number 7 concerning her social media activity during the trial. Additionally, juror number 5 appeared on the podcast Surviving the Survivor. During his appearance, he revealed he considered how Mrs. Adelson reacted to the evidence and testimony admitted during the trial. Although he subsequently stated he obviously did not consider that during deliberations, that he considered Mrs. Adelson's reactions whatsoever is concerning, as her reactions are not evidence and are extrinsic or external rather than that which adheres to the verdict. Oh, no, that's bupkis. Okay, listen. The juror's job is to be a judge of the facts. And one of those things one of the things that they have to, I guess, weigh is the credibility of the testimony and the witnesses. I think it's perfectly fine to look over at the defendant. While we got a witness on the stand over here, I'm pretending I'm in a jury box, right? But we got a witness on the stand. They're saying something. We look over at the juror. She smirks, or she smacks her lips, or she doesn't say anything at all, or she makes no movement, or she goes, or she clutches her pearls. Their job is to assess the credibility of the witness. I think that's perfectly fair what he's describing here. Okay, as a result, the undersigned seeks to interview juror number 7 concerning his consideration of Mrs. Adelson's reactions to the evidence. Maybe the defense is kind of just upset because their client was reacting to the evidence. Okay, discussion of law. According to the Florida Supreme Court of Juror Misconduct Discussion of Law, potentially harmful juror misconduct is presumptively prejudicial. A party seeking a juror interview does not have to conclusively establish that the alleged juror misconduct occurred and actually prejudiced his case. Okay. Rather, it is only necessary that the party establish a basis for the inquiry or grounds the party believes may exist. Once improper contact or juror misconduct is established by juror interview, the moving party is entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. If juror misconduct is confirmed from the juror interviews, the undersigned will request leave to make more extensive arguments concerning why the juror misconduct in this case warrants a new trial. All right, verdict is contrary to the law or the weight of the evidence. The only avenue for judicial review of the weight of the evidence is by motion for new trial at the trial court level. Okay, blah, 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 blah. Okay, blah, blah, blah. Yeah, talking about case law. Case law, case law. Let's see. Let's go back. Okay. A motion for a new trial requires a trial court to evaluate whether a jury's verdict is contrary to the weight of the evidence and to act in effect as an additional juror. This standard is different than the one used by a court in ruling on a motion for a judgment of acquittal, which utilizes a sufficiency of the evidence standard. Florida courts have held multiple times that when considering the motion for a new trial under that rule based on a claim that the verdict is against the weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. The trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. When determining the weight of the evidence, in essence, the trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. The role of the trial judge in passing on motion for new trial on the ground that jury verdict is contrary to weight of evidence is to weigh all of the evidence and determine credibility of witnesses so as to act, in effect, as an additional juror. Okay. Count 1, first-degree murder. At this stage, the court must make a finding that Patricia Bird was credible before considering Mrs. Adelson's alleged confession to Bird. Well, this is what the jury would do. Under no set of circumstances can Bird be considered credible. The only people who determine who is credible and who is not are the jurors. It's nobody else's. They're the ones that establish credibility. Okay, she testified the defense investigator with whom she spoke was a white woman. Ms. Khan is obviously not white. Oh, okay. She further testified that she told Mr. Varnes and Ms. Khan that Mrs. Adelson confessed and that Mrs. Adelson offered her financial incentives in exchange for perjured testimony. Both Mr. Varnes and Ms. Khan disputed those claims. Additionally, Ms. Khan testified she never met with Mrs. Adelson. Thus, unless the court were to believe defense counsel conveyed to Ms. Khan that Ms. Bird was to be offered money for false testimony, Ms. Bird's testimony should be disregarded completely. Again, who is to judge the credibility of witnesses? I mean, it's in the jury instructions, for crying out loud. Okay, the same is true of Drina Bernhardt. Ms. Bernhardt's motivation to lie was and is significant. With 27 felony convictions and facing a mandatory 15-year prison sentence as a prison release reoffender, Bernhardt's credibility was significantly impeached. The only one who testified this was Mrs. Adelson's words rather The only one who testified this was Mrs. Adelson's words rather than Ms. Bernhardt was Ms. Bernhardt. However, the surveillance video admitted into evidence established that she and Mrs. Adelson worked together to write the script. The theory of the state's case was that the defendant is guilty as a principal to the charge of murder because she agreed to the plan that was carried out by her son, Catherine Magbanua, Sigfredo Garcia, and Luis Rivera, and that she paid for the crime be carried out. Okay, we all do typos. In fact, you know what, guys? I wrote a letter this very week. First letter I've written in a long time where I full on put it in the mail. And I proofed it, I reread it, made sure everything was cool. I signed it, I folded it up, put it in an envelope, did my little licky, and sealed the envelope. Take it to the post office, put some stamps on it, send it off. Okay. Then I come back to the house and the letter is still up on my screen. And I realize that the very first word, your, is misspelled as Y-O-U-R instead of Y-O-U''RE. But it was already mailed. So I guess that I should be able to get past that she paid for the crime be carried out. It's cool. We all have, this is a long document, okay, Gavin? Just relax. There's no evidence that Mrs. Adelson committed any act or uttered any words in furtherance of the offense prior to it being completed, and for that reason, the evidence is not sufficient to support her conviction as a principal to first-degree murder. Additionally, there is no evidence okay, that's twice. I'm sorry, that's twice. No, we're gonna extend grace, but come on. Other the adopted admission from Charlie Adelson's trial testimony that Mrs. Adelson was aware of her son's plans until September 17th, 2014. Zellman's Law. Although a person can be convicted as a principal to a criminal offense based on words alone, there must be competent substantial evidence these words were spoken in advance of the crime. A person can be convicted as principal to a crime under section blah, 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 only if there is evidence that he or she committed some act or uttered some words to assist another in the commission of the crime when the crime was being carried out. I mean, I feel like there was enough evidence there. But okay. I mean, like the whole bump thing where, I don't know. Okay, the bump, right? It causes Donna and Charlie to get to talkie, right? It's the exact reason for the bump. That's its design. Are they claiming that she only knew after the fact and now she's trying to cover it up? She wasn't a principal? I don't, it's so dumb. The elements of the crime are set out in the leading case of Staten v. State, and it says blah, blah, blah. As acknowledged previously, intent is an operation of the mind and may be established by circumstantial evidence. There certainly is no direct evidence Mrs. Adelson intended for Mr. Markel to be killed. However, there also is no circumstantial evidence that Mrs. Adelson wanted Mr. Markel to be killed. I feel like there is. I need to think about it for a second. Circumstantial evidence that she wanted him killed. Well, she was doing horrible things, man. She was like she was threatening, she was advising Wendy to threaten to convert her children to Catholicism. It was just mean. I think that in total, as all these things fell on the jury, they're like, yeah, she wanted it done. But okay. Even if there's no evidence to establish the second element that she did some act to assist the other person in actually committing the crime. Magbanwa testified that per Charlie Adelson, his parents had stopped by his residence on July 18th after Mr. Markel was murdered. However, Magbanwa did not testify that Mrs. Adelson or her husband dropped off any money that night, and the state's expert agreed the state could not place Mrs. Adelson's or Dr. Harvey Adelson's handsets at Charlie Adelson's residence on July 18th. Even if Mrs. Adelson and Dr. Harvey Adelson did stop at his residence, it would have been approximately 9 hours after Mr. Markel was shot. I think in the grand scheme of things, that's close enough. In fact, they continue in paragraph 27. At the state's request, the court found that Mrs. Adelson had adopted Charlie Adelson's prior testimony. This included Charlie's testimony that he paid Magbanwa from his own money, which he kept stapled, as confirmed by Magbanwa. Yeah, but it was wet. But it was wet. I mean, come on. Okay, as confirmed by Magbanwa, Ryan Fitzpatrick, and June Chinda. Charlie's testimony also included the fact that he did not tell Mrs. Adelson he paid Magbanwa for the shooting until September 17th. No evidence was presented that Mrs. Adelson was aware of anything other than Mr. Markel had been killed prior to September 17th. The defendant in Staten drove the perpetrators to the scene of the crime, waited across the street while they were committing the crime, and then drove them away in the car. In these circumstances, the jury could legitimately infer that petitioner was a participant in the crime, and thus the Supreme Court concluded that the evidence supported the defendant's conviction as a principal. Affirmative acts such as these are common in prosecutions under the principal statute. Okay, blah, 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 blah. Blah, 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 definitely in Williams, blah, blah, blah. There's just lots. Okay, let's go here to paragraph 33. Actually, let's pause for a second. Let's see what you guys are saying over here in the tank. Let's see. It's scrolling up. Mooney says, I hope we get to see the state's response to this. I think we will. Robin says, Gavin is just beginning to come to terms with what happens when you get to age 50 plus. Soon the middle-age game of charades for lost words will begin. When in doubt, act it out. That's funny. Okay, first of all, I am not 50 plus for another 2 weeks. All right. And and it's not midlife. Okay. How many 100-year-olds do you know? I am beyond midlife. But yeah, I am having a bit of a crisis. It is true. It is true, and I've shared that with you guys. You guys have been amazing. Um, Susan, how can juror number 7 posting that she was chosen as a juror have possibly affected the verdict? This was before she heard any evidence, if it happened at all. Yeah, and I don't know if it's clear that she said that she was a juror in the Donna Adelson case, just that she was selected as a juror. Yeah, I'm with you on that, Susan. Robin gets it. Robin gets it. Yeah. Can you believe that? I wrote the wrong your. That's one of the cardinal sins of letter writing, man. I you know what I should have done? I should have taken the time to handwrite it. I typed it. I was a little bit lazy, but also I care about the people who received the letter and I want them to actually be able to read, so I typed it. But yeah, I made so many mistakes. I think I was just so giddy that I had written a letter that I didn't proof well enough. Ah, coffee, please. Spanish is my first language. I always get your and your wrong. You know what? Then you are forgiven, but I am not. I need to deeply repent before any forgiveness can be offered to me. Mooney, what's the old saying? Punctuation can kill you. Yeah. Let's eat, Grandma. Let's eat. Let's eat, Grandma. Yeah, that's pretty funny. Yeah. Oh my goodness. Susan, too bad the defense didn't use any of these arguments at the actual trial. Indeed. Indeed, indeed. Uh, Kel says, this is Grandma Donna stamping her tiny feet and pulling a face and throwing a toddler tantrum. Such a waste of the court's time. I think that we're going to get a lot of these. I really do. The jurors that she wants to question will probably have to hire lawyers. This will cost them money for speaking out. Can they ask for public defenders or have Donna pay their fees? I don't think so. I don't think so, Zach. Uh, yeah, the money was wet, and Donna admitted she laundered it. Correct. The money was wet. Oh my goodness. That is the best little detail. Now, we cannot forget. Like, you guys realize that we can't forget that a man was murdered here, right? So I get it. But as stupid criminals go, the laundering the money thing is just it just tickles me. It does. Tickles me. I love it so much. Um okay. Susan, the wrong your blame autocorrect. Well, we'll see if these people respond to the letter I wrote. But I think the best thing for me is just to be honest, say I'm sorry that the very first word was misspelled. Oh, goodness. Have I told you guys I've got a trip back home coming up, which is going to be fun? I am. I'm excited to head to back to California to visit the old family, see some old friends. Uh, Mooney, your dog went nuts at my sound. My protracted mm. Okay. Well, I apologize. Hope that little pupper's okay. All right, let's go back over here. Wrong here. Let's go here. Okie dokie. Paragraph 33. The state may argue that Mrs. Adelson's act of delivering money, wet money, to her son's house sufficiently establishes what she did the day of the murder. However, nothing about delivering money after the murder could support her conviction as a principal to the murder itself. Additionally, there's no evidence of what Mrs. Adelson agreed to pay the killers prior to the murder. In fact, Magbanwa testified during trial that the amount of payment was never addressed prior to the murder. The state may also argue that Mrs. Adelson necessarily provided Mr. Markel's tag number to her son, who gave it to Magbanwa, who then gave it to Garcia and Rivera. However, there's no evidence the tag number was ever given to Charlie, let alone Magbanwa, Garcia, or Rivera. Even if such evidence existed, existed, there's no evidence this was done on or even before July 18th, 2014. No evidence was admitted during trial to establish the purpose for which Mrs. Adelson had the tag number in her 2014 planner. Why would you have, why would you have a tag number in your planner? The only tag numbers of any family member of mine that I know, I only know because they're vanity tags, right? They say they make up words, right? They're vanity plates. So why would I don't understand why I couldn't tell you the tag number of my vehicle right now. It starts with a K. Anyway, yeah. Okay, finally, with respect to the second principal instruction, there is no evidence Mrs. Adelson made any payment prior to the murder or that she, rather than Charlie, promised any payment prior to the murder. At worst, even if Mrs. Adelson dropped cash off at Charlie's house after the murder and signed the payroll checks after the murder, would establish her culpability. Okay, I'm having a hard time. At worst, even if Mrs. Adelson dropped off cash at Charlie's house after the murder, comma, and signed the payroll checks after the murder, no comma, and then would establish her culpability as an accessory after the fact, at worst, even if Mrs. Adelson dropped off cash at Charlie's house after the murder and signed the payroll checks after the murder would establish, even if, okay, there's just a missing comma. Even if it would establish her culpability as an accessory after the fact, but are not competent evidence as a principal to first-degree murder. I feel like something's missing in that sentence, but okay, count two. Conspiracy to commit first-degree murder. The state's theory on count two was that Mrs. Adelson agreed with Charlie Adelson and others to kill Mr. Markel. As was clear throughout the trial, there was no direct evidence of Mrs. Adelson's involvement in the conspiracy. The state proved as to Charlie Adelson, Magbanua, Rivera, and Garcia. The primary evidence against Mrs. Adelson was the motive. Mrs. Adelson desired to have her daughter and grandsons moved to South Florida. Although there was certainly evidence Mrs. Adelson was not happy with the way Mr. Markel treated her daughter in the litigation process, there was no evidence Mrs. Adelson said or did anything to suggest Mr. Markel be killed a year after relocation was denied and the dissolution of the marriage had been settled. There was no evidence Mrs. Adelson was even aware, according to Jeff Lacassie, that Charlie Adelson looked into hiring a hitman in the summer of 2013. To establish a prima facie case of conspiracy, the state had to admit evidence that A, the intent of Donna Adelson was that the offense of first-degree murder would be committed, and B, in order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated. Man, that was really good. Conspired, combined, confederated. I forgive this writer for the previous blunders. That's well written. With Charles Adelson or Magbanua or other persons to cause first-degree murder to be committed either by them or one of them or by some other person. The undersigned asked the court to consider the evidence without the state's spin placed on it. Certainly, Mrs. Adelson suggested crazy and offensive methods to her daughter to convince Mr. Markel to change his mind about relocation. Once the dissolution was final on the 31st of July, what evidence exists that Mrs. Adelson continued to have a motive for Mr. Markel to be out of the picture, if we ignore the emails where she suggested her daughter ensure Mr. Markel be obligated to share expenses with her for their son's college education, etc., all events which would necessarily take place after he was killed? There is none. Where is the evidence Mrs. Adelson agreed, conspired, combined, or confederated with anyone else that Mr. Markel be killed? There is none. The state's entire case is premised on speculation, impermissible stacking of inferences and theory without the speculation theory and impermissible stacking of inferences. There was no evidence Mrs. Adelson ever agreed for Mr. Markel to be killed. Oh, evidence of the flight. The one-way ticket to Vietnam. The evidence of flight was not that she was fleeing to avoid prosecution, but that at that time, in November 23, she believed in her son's innocence and that if he were convicted, the state would next turn their attention to her. Rather than consciousness of guilt, that is evidence of her real fear the witch hunt would continue. Guys, I love good lawyering. This is not. I'm sorry. That is not compelling at all. I I want to be convinced. As a layperson, I want to be convinced. That is not convincing. Oh, I don't know. This count 3 solicitation. Yeah. Okay, let's skip down here. Okay. For other cause not due to Mrs. Adelson's fault, she did not receive a fair and impartial trial. Paragraph 59. It goes without saying that all defendants are guaranteed a fair and impartial trial under the Florida and United States constitutions. The Due Process Clause of the 14th Amendment guarantees the right of state criminal defendants to be tried by an impartial jury. The 14th Amendment incorporates the essence of the 6th Amendment right to be tried by a panel of impartial, indifferent jurors whose verdict must be based upon the evidence developed at trial. As Chief Justice Warren has observed, the constitutional guarantee of due process requires the courts to safeguard against the intrusion of factors into the trial process that tend to subvert its purpose. Specifically, the courts must vigilantly guard against the atmosphere in and around the courtroom becoming so hostile as to interfere with the trial process, even though all the forms of trial conformed to the requirements of law. Okay, case law, case law. Case law, case law. A defendant claiming she was denied a fair trial must show either blah, blah, blah. Actual prejudice requires blah, blah, blah. Inherent prejudice, on the other hand, requires a showing by the defendant that there was an unacceptable risk of impermissible factors coming into play. This is a case where the cumulative efforts of a number of factors constitute inherent prejudice resulting in Mrs. Adelson not receiving a fair trial. When the court would rule against the defendant, on many occasions, the members of the gallery supporting the state would laugh out loud. That is an issue. That's not cool. Counsel for the defendant brought this to the attention of the court, and the court appropriately advised the gallery this was not acceptable. The court did this on more than one occasion. However, the conduct continued throughout the trial, and the court took no action to remove those who violated his order. This undermined the credibility of the defense in the eyes of the jurors. Okay. I mean, that's a compelling argument to me. Not only were they laughing out loud, videos and images captured through the live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. I did not see any of that. This interfered with the jurors' ability to focus on the evidence and distracted them from closing arguments. Yeah, I didn't see that. If one of you saw it, I'd love to hear your comments. The court admonished the defendant on numerous occasions that she was not permitted to show any emotion in the presence of the jury. The law does not require that a defendant appear without any emotion. In fact, as in this case, appearing to be cold to the seriousness and evidence in the case may cause the jury to believe the defendant had no care or concern for what the victim endured. During the course of the trial, prior to the reading of the verdict, the defendant did not do anything to disrupt the proceedings. She did become tearful during her first sight of autopsy photographs and got choked up when her children appeared to testify against her. She did not speak out. She was not sobbing out loud. She was not crying. She did need tissues to wipe away her tears, but she made no noises that distracted the jury in any way. Even the victim's parents noted that she showed no remorse due to her lack of emotion during the trial. This impacted the decision of the jury, resulting in Mrs. Adelson not receiving a fair trial. Okay. The state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense's case, the court demanded that Mrs. Adelson decide whether she would testify. Both counsel for Mrs. Adelson as well as Mrs. Adelson herself repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during trial in order to make a knowing and intelligent decision in what was probably the most important decision of her life. This was especially significant in that the state made numerous changes to evidence during the trial, which they can. They can do that. I do remember the judge asking the defense what her decision was. And I mean, any court proceedings that I've witnessed, like live, any trials that I've witnessed, that's usually like the very last thing. The very last thing. There will be a hearing outside of the presence of the jury. They will ask whether or not the defendant wants to testify or has decided to testify or not. They explain the rights and blah, blah, blah. So yeah, that is kind of weird. Let's When the court recessed early on the 2nd to allow counsel to meet with Mrs. Adelson, we first spent a great deal of time reviewing the exhibits actually admitted so that we could discuss them with Mrs. Adelson. Counsel then drove to the detention center to meet with Mrs. Adelson for the 2 hours authorized, arriving at approximately 5 p.m. Counsel did not have enough time to go through every exhibit with Mrs. Adelson during this meeting. Counsel advised the court of this fact the following day when the court inquired about Mrs. Adelson's decision. Not only did the court force the defendant to make an uninformed decision, he threatened to hold counsel for the defendant in contempt of court because they were continuing to speak to their client about this important decision that she had to make, which again brought an audible derogatory response from the gallery, which wouldn't have been in the presence of the jury. Oddly enough, whenever the state needed additional time to set up electronics for opening statement, for witness testimony, for closing arguments, and even additional time to make their closing argument, the court not only gave them additional time, he joked with the prosecutors about it, thus leaving the clear impression that he favored the state in this case. Surely the decision of a defendant facing life in prison is more important than the extra time the state requested to conclude its closing argument. The defendant's request was not granted and made a huge impact on the outcome of the case. Okay. The court showed favoritism to the state at most every juncture of the trial. While the trial had delayed starting times to accommodate the state's needs, the defense was required to meet its tasks over the lunch breaks, thus not allowing counsel time to adequately meet the obligations of counsel for the trial, resulting in the inability to consume lunch over the break. The court sustained the objections of the state without giving the defense an opportunity to respond. Under some situations, sidebar arguments were made, but on more than one occasion, the court denied the defense's request to approach. Additionally, even when the court sustained a defense objection at sidebar, when the sidebar was concluded, the court announced to the jury that the objection was overruled. During one sidebar discussion, the court asked counsel a question. As counsel attempted to answer the question, counsel was met with a scolding to not talk over the court. Counsel thereafter was prevented from answering the court's questions. The temperament of the court towards the defense counsel was regarded as negative and gave the appearance of partiality for the state, but on the part of the court, to not only the defense, but spectators in the gallery, the media, and those viewing the trial through the media. Fellow defense attorneys commented that they had appeared before the court in trial on similar charges, and they were shocked to see the obvious disdain the court showed towards Mrs. Adelson and her counsel in the case. I mean, okay, that feels pretty subjective. Plus, I guess I feel disdain toward Mrs. Adelson. So, although there is a standard jury instruction to the jury that they are to disregard anything the court may have done that led them to believe he favored one outcome over another, and that was read in this case, it is not realistic that a jury can set those feelings aside. The jury clearly disregarded the instructions of the court on other issues and did so on this instruction as well. The totality of circumstances present during Mrs. Adelson's trial establish inherent prejudice. To wit, there was an unacceptable risk of impermissible impermissible factors coming into play, wherefore the defendant respectfully requests that this honorable court grant this motion, grant Mrs. Adelson a new trial, and for such further relief as is just and proper. I don't. No, I'm not terribly convinced by this motion. I'm not convinced at all. Let's see. Let's see what you guys are saying. A 35-year banking, washing that money just hits me in my funny bone. Yeah, it tickles me. I think it's hilarious. Oh, just somebody trying to be a criminal mastermind. Susan, why would you have your ex-son-in-law's tag number in your planner in the first place? Yeah, it's weird. That's just weird. Peppermint says, I am a cutie pie. Peppermint apparently is into almost 50-year-old graying fat guys with unruly hair. But thank you, Peppermint. Couple more down here at the bottom. Susan says the court gave her so much extra time to make up her mind about testifying. And let's talk disabilities. Gavin, I do think it's odd that the public, and I'm sure the jury, do notice the defendants don't appear to feel remorse, but the defendants can't show emotions. Yeah, you're right. It is odd. I'm not sure if why that instruction is there, but it does seem to be the general, the general attitude that I see in court. Gavin, you need to pull your hair back, that glorious mane. No, right now you see, Jen, what I'm doing is I'm looking, I'm in my Barry Gibb phase, right? Like, I don't know. I need more hairspray, of course. But, and I will have you guys know, by the way, guys, the whole hair thing is so stupid. But what I'm doing is I'm growing out my hair to try to donate it. And I think I've hit a very important milestone, and that is this. I can pull it back into a ponytail now. Like just I can pull it all back and it gets all of it except the little wispies. I can do that now, which is pretty great. And I do that. I have been working out because of my crisis, my 50th birthday crisis, I guess. And that's what I've been doing. I've been putting my hair back, but yeah. Jen says my hair is in the same phase, Amelia. Well, good. I'm not alone. Mooney, I don't think it's man bun time quite yet because I can't get it high enough because the bottom isn't long enough. It has to be it's kind of like a cheerleader pony when it's all said and done. It's like one of those that you might put out the back of your baseball cap, That's kind of how it is. Do I have a dime ponytail? What is a dime ponytail? I don't know what a dime ponytail is. Somebody explain what is a dime ponytail. And then I will be able to answer you whether I have one or not. You guys, you got to tell me about my collar, okay? I just noticed it. My fancy striped shirt that my wife bought me. What do the kids say about the hair? I think they're mostly ambivalent. We do have a son who has had long hair and he thinks he likes it, but then he points out that I have like a 6 head, right? So there's that. Autumn can't wait to see me in a man bun. Jen votes a man bun, but somebody tell me what a dime ponytail is. I don't know what a dime ponytail is. I'll figure it out before the next time we meet, which shall be tomorrow. By the way, on Friday, we're going to be having Elizabeth Jones. Oh, let's see. Jen says, a dime ponytail is when your hair is as thick as a dime, as fine-haired baby blondes. No, for a man my age, I've got a pretty thick, though receded head of hair. It's not as thick as like our daughters or my wife, but it's pretty thick. We have thick hair in our family. Yeah. But yeah, thank you for teaching me what that is. I had no idea. Our daughters, man, holy cow, our daughters, they have thick hair. Those ponytails are like that thick. It's just crazy. They always have been that way. And Kimberly has thick hair too. All right, guys, that's it. I was gonna say Friday we have Elizabeth Jones coming on, and we're going to be talking about the Mickey Steins case on Friday. Remember that you can always go to Meal website, gavinfish.com, to check out anything new on Crime Cod. Oh my goodness, there are a couple of new stories on Crime Cod that are just heartbreaking. Please check those out. I am working on my next blog post. You can check out cases that I have done deep dives in whatever, things like Maddie, things like Ellen, things like cases like Grace Holland, David Elmquist, um, you know, so many that I care about, Amanda Winkowski. So please go ahead and check that out if you like to dig into the nitty gritty of cases like I do. Remember that if you click on this little fishy right there, that will take you to the fish tank where we hang out on Facebook. And yeah, I think I need to convince my wife to post more on Facebook. She's kind of slacked. She's kind of slacked in the tank. Got to get a little bit more Kimberly content out there. Okay, with that, guys, it is time to say goodbye. I don't have any like parting words of wisdom other than to just bid you adieu. Go with God, my friends, and I will see you on the next one. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.